Appeals. We have two cases on the 130 docket, People versus Sims and Lucas versus Cumming. We have two experienced counsel at the table, but I'll just remind people that you have to turn your cell phones off, not just to vibrate. I'm not sure why, that's all I know. And also in Sims, I'm sure you will be careful not to mention any of the victims' names. 15 minutes per side. You'll keep track of your own clock. Any questions about anything? All right, then we're ready to go.
Good afternoon. May it please the court. My name is Mark Walta, registration number 30990. I am appearing on behalf of Samuel Sims, the appellant in this matter. I'm obviously happy to answer any questions that the panel may have about any of the issues raised on appeal, but my intention here is to focus on the first issue regarding the legal effect of the superseding indictment that was handed down in this case. It may go without saying, but I'm going to say it anyhow. By not arguing the other issues, I'm in no way waiving or abandoning them, and it's not meant to be a commentary on my view of the relative merits of those issues, but it appears to me that the first issue presents a question of first impression in Colorado. I have not found a great deal of case law or commentary around the country on this particular issue. So I thought it would be worthwhile to spend some time on this. The issue, at least in its broad outlines, is fairly straightforward. Does a superseding indictment actually supersede or supplant the original indictment? And secondarily, if so, when does the superseding indictment take the place of the original indictment? As an initial matter, it is not Mr. Sims's position that the original indictment did not properly invoke the jurisdiction of the trial court. It did. The issue is whether the superseding indictment nullified or supplanted the original indictment and thereby deprived the trial court of jurisdiction over the charges contained in the original indictment.
Can I ask you a quick hypothetical question?
Sure.
Let's say the DA had gone to the grand jury and instead of stamping superseding indictment on the piece of paper, had put superseding count 7, or had put superseding 1 count, second indictment, and then had written underneath it something like, this second indictment does not otherwise supersede the original indictment, except for count 7.
Well, I don't think it's purely a matter of semantics, and that's not the way that I hope we've presented it. In my view, a superseding indictment, irrespective of what you call it, irrespective of what qualifiers you put on it, is nevertheless a superseding indictment.
But why couldn't the DA have done that? Is there something preventing the DA from doing that?
Well,
it seems that that's what the DA was trying to do.
it's not clear to me what the DA was trying to do, quite frankly. I understand that they were focused solely on the count of sexual assault in this case, which they initially attempted to amend via Rule 6.8, which, to the extent that there's any doubt on the part of the court, I think was clearly improper. It was, in my view, was clearly an amendment as to the substance. It ended up charging actually a crime that doesn't even exist anymore, first-degree sexual assault. And moreover, if you look at the language of the amended or superseding counts, it's actually quite different than the language that was contained in the original indictment. So to the extent that there's any concern on the part of the court that the superseding indictment that the district attorney did seek was superfluous and unnecessary, we disagree with that. And I think in the end, the district attorney ended up coming around to the view that they did have to return to the grand jury in order to, in their view, amend the count in that fashion.
But counsel, it seems to me you're saying, in effect, that when they decided to do that, they also had to go back to the grand jury, represent their case on every charge, and get a new indictment on every charge. What law supports that?
Well, I think that's certainly standard practice, in my view. And I have not seen a situation like this where the prosecution returns to the grand jury on a single count. Usually when there's a superseding indictment, it encompasses all of the counts originally charged in the original indictment. Now, as to, is there a specific law that I can point to? The answer is no.
Or case law, anything?
Well, there's no mention of superseding indictments even in the rules of procedure. And so in that respect, the procedure, obviously, the rule contemplates that there can be no substantive amendments to the indictment. The only way to do it is to return to the grand jury. And even then, it's not, I think, Professor Dieter in his treatise notes that a superseding indictment is not an amendment. It's simply the action of the grand jury producing a new indictment and expressing the will of the grand jury in terms of what it believes, which charges are merited in the case. So in that regard, I don't know that you can go back to the grand jury and seek an amendment per se. That's not what the jury is doing when they are convened for the purposes of considering and issuing a superseding indictment.
But I think the flip side is, well, there's no law that says they can't. And given all that, it does seem that your argument just boils down to semantics. I'm relying on the dictionary definition of superseding, period.
Well, were it not for the fact that courts recognize that superseding indictments have this effect, that they do, in fact, supersede the original indictment. Now, courts differ, of course, about the effect of that. A very small body, and I understand this is the minority view, seem to suggest that the superseding indictment does have the effect of nullifying the original indictment. I think the majority view is, well, the two indictments can coexist up to a point, but the prosecution can only proceed ultimately on one indictment and has to elect before the case goes to trial.
Can I just back you up for 1 second?
Mm-hmm.
It seems like in the cases, I don't have any quibble with you about the fact that superseding usually means supplanting or replacing. But it seems like in those cases where the courts are stewing about this, the superseding indictment does have different, it's not just one count. They're not just returning a new one count. It's a new indictment that logically would supersede the old one because the two can't really coexist. That's why they have an election at the end, because otherwise you're facing, instead of 8 charges, 16 charges. That doesn't seem fair. But here you just have one count that's being superseded. So those cases don't seem to help that much in terms of the analysis.
Well, what I find curious is either prosecution in both state and federal prosecutions have largely been doing this wrong, and the prosecution got it right, in that they only go back and target the one count that they're seeking to amend. But typically, at least in my experience, when the prosecution is going to go back to the grand jury, and even if they are amending only one count, they will still represent the case to the grand jury, and what will be produced is a second superseding indictment that encompasses all of the original charges.
Right, no question you could do it that way, and maybe most people do it that way. But the question is whether or not there's a subject matter jurisdiction bar to doing it the other way. I mean, this is a heavy burden. You have to show not just that this is not really the way people typically do it, but that it divested the court of subject matter jurisdiction to even like resolve the case. I'm having trouble with that link as well.
Well, certainly if you accept our premise that and I understand that the court appears skeptical of it, but clearly if you accept the premise that you can only go to trial on one indictment, and that seems to be the majority of view, at least as expressed by several federal circuit courts. I don't know why the same principle doesn't apply here when you have what was clearly characterized and meant to be a superseding indictment. Why the mechanism would be any different, or the jurisdictional concerns about having two indictments coexisting up through the point of verdict in the trial. I guess I'm having a difficult time drawing the distinction between a situation in which the prosecution has returned a full-blown superseding indictment that encompasses all of the charges contained in the original, with whatever amendments have been imported into the superseding indictment, and the fact that they've just issued a superseding indictment with a single count.
So your argument would be they needed to elect which sex assault count they wanted to go forward on, at a minimum, you're saying. Well, now we have two indictments that charge a sex assault, so at a minimum, you should have decided which sex assault count you wanted to go forward on.
That would not be our position. That's not been our position. Our position has been that they had to elect between the original indictment and the superseding indictment prior to trial.
Okay, but
So-
there's not two, I'm sorry.
No, go
There's
ahead.
not, those indictments can coexist because there's only one set of murder charges. And then, fair enough, appear to be two sex assault counts, but only one set of murder charges. So it's not as though there are two sets of those charges coexisting in the two indictments.
Well, and I guess the problem is that if each of the indictments is an expression of the will of the grand jury, it's difficult to suss out whether the will of the grand jury that issued the superseding indictment was necessarily, and I think this is where the trial court was going, there was the implication that the grand jury, accepted the murder charges in the original indictment. I don't think that the trial court or this court can go behind the indictment to determine the will of the grand jury through transcripts of the grand jury proceedings or whatever. I think that the superseding indictment is an expression of the grand jury's will.
But counsel, it seems that you're arguing really that we can't consider anything except the label. We can't consider the circumstances. We can't consider the actual indictments. We can just consider the label.
Well, the label is important, Your Honor.
Well, but it's not dispositive. I mean, we have to look at things in context. What if, take off on Judge Harris's earlier question, it had been labeled partially superseding indictment? Would you be making this argument?
Probably not. Probably not.
All right, so,
I think it would be a much more difficult argument to make.
or say supplemental indictment, or indictment as to sex assault charge. I mean, it seems, again, this just seems like a semantic argument. And you're saying that because of semantics, the court doesn't have subject matter jurisdiction.
Well, all I'm doing is based on the existing law, and there's very little out there, suggesting that two indictments can only coexist up until the time of trial. And I think the clear implication of those is that there is no jurisdiction to entertain both indictments simultaneously. That is the basis for our jurisdictional argument. If the court has no other questions, I will reserve the very little time that I have left. Thank you.
Good afternoon. May it please the court. Kevin McReynolds on behalf of the people. I think there's three fatal flaws with defendant's position here, which is basically semantics. First, it's based on an incorrect legal premise because there is no jurisdictional issue here, and defendant almost conceded as much up front where he suggested that the original indictment did properly invoke the court's subject matter jurisdiction regarding the murder charges. Second, it's based on a hyper-technical view of pleadings, which is contrary to the notice pleading regime that's been in place since at least 1963 when the rules of criminal procedure were adopted. And third, it's factually and legally incorrect because all of the superseding indictment cases he relies on don't support his point. They only involve that we have to elect between two competing indictments covering the same criminal conduct. That is what those cases stand for, and that's what actually happened here, where we proceeded with the original indictment on the murder charges and the superseding indictment that replaced and supplanted the sex assault charges was proceeded along with the statutory language changed there. So turning first to the jurisdictional
Sorry,
point.
could I just
Yes.
ask you a factual clarifying question?
Yes.
Did the DA dismiss the original sex assault count?
No, Your Honor. The DA proceeded with the new sex assault count. And just to bring you back factually, circumstantially, how this happened, it was really about adjusting the language of the count, not to change who, what, where, when, or how, but to change the language to track the 1994 sex assault statute. Because this was a cold case, they had to use the criminal statute that existed at the time, and the original indictment did not track that language, and that was the reason for this entire procedure. So they did not expressly dismiss the original indictment. They proceeded forward with the sex assault charge as alleged in the superseding sex assault charge. But to turn back, first point, jurisdiction. District court had jurisdiction over the murder charges from the moment that a substantively correct indictment was issued on that invoked the court's subject matter jurisdiction. And subject matter jurisdiction is very broad. It's constitutionally granted. It can't really be cut back without explicit legislation. And here, no statute, no rule, no case, no fact supports defendant's claim that somehow a replacement of one charge stripped the court of that subject matter jurisdiction that he has admitted was properly invoked through a substantively correct indictment. So those murder charges, there was jurisdiction over them from that point. And if you game this out as to how it would play out, I mean, defendant's position is essentially the court had subject matter jurisdiction over the murder charges, and then it disappeared when there was a grand jury proceeding later that did not discuss or address the murder charges at all. It was focused exclusively on the question of the sex assault charges, and then a replacement charge was put in place for that, and that impacted a prior probable cause finding that had nothing to do with what was discussed or covered in that subsequent hearing.
Counsel, can I
Yes.
ask a question going back to Judge Harris' former question about the dismissal? Without there being a dismissal of the original sexual assault count, Did that then set up a situation where there were competing counts with regard to the sexual assault that?
I think you could view the record that way as they're being competing, and then I would turn to all the federal case law that points to you can have coexisting superseding and original indictments on the same criminal conduct, and it has to be elected, and that was effectively done here. The prosecution proceeded with the clarified language and with the correct language with regard to the instructions and so forth on the sex assault.
So your position is that can constitute then the election? There doesn't have to be anything specific?
I don't believe
More
the,
specific.
yeah, I don't believe even the case law that's addressing this, including like the trial court case law, necessarily requires explicit. Now I'm proceeding on this. We have the charges. He had what we require for pleading purposes is constitutional notice and an opportunity to defend. He had that here. He doesn't dispute that he had that here. He doesn't dispute that the murder charges were substantively correct and in accord with the requirements of 16.5.201, what we have to have for a substantively correct indictment. He doesn't challenge that the updated indictment regarding the sex assault charges was substantively accurate and gave him that constitutional notice and opportunity to defend. It's really a hyper-technical gotcha argument of there was this other word here, and there's case law that we think should be expanded and changed to apply to a situation that none of those courts dealt with, and that therefore the jury's verdicts finding him guilty beyond a reasonable doubt of 3 counts of murder should be vacated, and he should go free for killing those people. I think that is a semantic argument. It's contrary to everything we have in pleading law, and it's contrary to U.S. Supreme Court case law, which basically in U.S. v. Cotton, which the people cited, says that pleading issues cannot strip a court of subject matter jurisdiction. But that is the heart of defendant's claim here, is that a pleading change that had no effect on his substantive rights, on his constitutional ability to have notice and opportunity to defend, stripped the court of subject matter jurisdiction. And that's not the law anywhere, and we should not make that the law here today.
Can you point us to any authority that says that the government can do what it did in this case, which is pluck out one of the counts, send it back to the grand jury? Now you've got 2 indictments, and it can, and you're saying the election didn't really require any election between the 2 indictments, that you can go forward on a mix and match of the 2 indictments. Any
I would
authority?
say the closest thing I could point to would be Crim P13, which has to do with when we consolidate different indictments or different informations for the purposes of a trial. The rule, defendant in his brief suggested a footnote that rule wouldn't apply here because this was within the same case, but the rule itself doesn't have any limitation like that. The case law instead on Rule 13 makes this a discretionary call for the court, and the only requirement really is that these are sufficiently connected factually or to a common scheme that it's appropriate to try them together. There's no reason that authority wouldn't support what was done here in terms of we did have absolutely a valid indictment for murder. We did have absolutely a valid indictment for the sex assault charges. They were tried together because factually that made sense. And there is no substantive prejudice at all, nothing changing the subject matter jurisdiction of the court. It was properly invoked, and from that point forward, it should be, it was permitted to proceed forward.
I think the question is, okay, it was properly invoked, but perhaps it was lost. I think that's the argument. Let me give you a hypothetical. Let's say that there is a single count indictment charging first-degree murder. The prosecution later goes back to the grand jury and, as to the same conduct, obtains an indictment for criminally negligent homicide. At that point, is there jurisdiction over the first-degree murder charge? Can the prosecution proceed and at trial elect which one, or at least over the defendant's objection? Is that a jurisdictional problem?
I don't think it's a jurisdictional problem, Your Honor. I think what we have there would be similar to what we have in those other superseding indictment cases where we have 2 competing indictments covering the same criminal conduct, And in those cases, it was found jurisdictionally, there's no problem, they can coexist. And then there can be an election between those charges as far as going forward to trial. I think that that's consistent with that. I think it's consistent with what the people's position is here, which is if you do have two grand jury indictments covering the same criminal conduct, I think there does need to be an election. I think that that's what the majority rule of the federal circuit courts provides.
So if I understand the position, it is that a subsequent indictment does not divest the court of any jurisdiction. It can't have that effect.
It can't
So
have
long
that
as it
effect.
was properly invoked in the first place, it can't have that effect. There may be some procedures that have to be followed at that point, but they don't go to jurisdiction.
Yes, Your Honor. And the people's primary position is there is no jurisdictional issue here. Once properly invoked, the court has subject matter jurisdiction over the criminal case. And that really is just as far as pleading, the question is it substantively correct under 16.5.201? Does it allege the who, what, where, and how, and track the language of the statute? If you have that, you have enough to have subject matter jurisdiction, and we move on to other questions that are not involved with subject matter jurisdiction. So lastly, I'd point to this court to just the factual and legal lack of support for defendant's position here. Factually, what we have here is the trial court reviewed the grand jury proceedings and made a factual determination that the grand jury's intent was only to address and replace the sex assault charge. And that's on the 7/15/14 transcript at pages 7 and 8. Trial court said, there's nothing in the testimony before the grand jury. There were no questions posed by the grand jurors during the superseding indictment hearings that would lead one to believe the grand jury did not intend for the homicides and other charges to remain viable. That factual finding, I think, should be reviewed under a clearly erroneous standard because it is a factual finding. While it has an impact as far as the legal application, it is a factual finding as to what the court found the grand jury was addressing. And I think that can potentially end the analysis here today because the grand jury proceedings were not included in the appellate record here, and thus we have a factual finding by the court that the basis for it is not the record, and we must presume things omitted from the record support the trial court's findings, and that would support the conclusion it reached, which is the grand jury did not intend to strip the court and remove the murder charges from this case.
But counsel, doesn't that put defense counsel in a very difficult position because, as I understand the law, defense counsel wouldn't be allowed to look at what the grand jury saw. Those proceedings are confidential. The defense is excluded from those and is not supposed to see them.
I would say that in this case, the primary grand jury proceedings were released to defendant. That's at the court file at page 30. There's an order releasing the grand jury proceedings to him. Given that case history, to the extent defendant didn't have access to these superseding indictment hearings, he certainly understood the venue and the method to request those from the trial court as the court had previously released grand jury transcripts to defendant.
It does, though, raise the question as to whether the court should have made the factual finding in the first place. That is, whether the court had any authority to do that, to go look behind the indictment itself, look at the testimony before the grand jury or any statements to the grand jury and see what it was up to. Are you aware of any authority that allows the court to do that?
I am not specifically aware of any authority. I would say that I don't have transcripts for those other superseding indictment type of court cases to be able to say what proceedings or what courts specifically were considering or looking at there. I would say that what we have here was an appropriate finding by the trial court. The trial court was asked the question, hey, doesn't the fact that this says the word superseding mean that we don't have murder charges anymore? Looked at it and said, they didn't even talk about the murder charges. How could they have been intending to strip the murder charges out and let you basically off the hook for killing 3 people based on the fact that they didn't talk about it? I think it's a perfectly appropriate factual finding to be made under those circumstances.
But wouldn't the counter to that just be that maybe the DA just decided he was going to go in a different direction? So he went in front of the grand jury. I mean, I think this is the theory. He went in front of the grand jury and he said, I'm not going to present the murder case. Maybe he thought he didn't have enough to go forward on the murder case. So he says, this case is now just a sex assault case. That's what I'm presenting to the grand jury. They return the superseding indictment. That's it. I mean, that's the theory on the other side.
Yeah, but the
So you
record
may
says-
think that that's unlikely, but I mean, that's the theory. Why?
Well, the record says otherwise itself, Your Honor. If you read the prosecution's argument in that same 7-15-14 hearing, that's their position is, we only went to them to correct this because we were worried that it would be a substantive amendment to do it through 6.8. So we went and represented just this to just replace this. There was no secret intent or no concern about, we don't want to go forward with the murder charges. So the record belies that type of a theory, Your Honor. And I see I'm out of time. If there are no further questions, we ask this court to affirm.
To be clear, Your Honor, our position is not that the prosecution's intent was to abandon the murder charges, but they had an opportunity to go back to the grand jury and do what, in my view, is the normal practice and represent the charges in their totality and to obtain a superseding indictment that contained the murder charges. They simply didn't do that. We think the legal effect of that is that the superseding indictment superseded the original. And we ask that the court either vacate the murder convictions or reverse for a new trial and an election. Thank you.
Thank you to both counsel. Excellent briefing and excellent arguments, very helpful to the court. We will issue an opinion in due course, and the case is now submitted. Okay, our next case is 2017-CA1531, Lucas versus Cumming. And were counsel in the courtroom when I made the announcements earlier?
I was present, Your Honor.
Okay. And Ms. Gill, I know you're an experienced lawyer here. Any questions about our oral argument procedures? Okay, great. So whenever you're ready, I don't mean to rush you, then we're ready to go.
Good afternoon, Your Honors. My name is Doug Thomas. I represent the plaintiff in this matter, Lindsay Lucas. My registration number is 23415. This appeal involves a claim in equity for unjust enrichment, and the primary issue on appeal is, did the trial court err in applying the generalized test for unjust enrichment found in the Supreme Court case of Salzman, as opposed to the specific test for unjust enrichment found in the Supreme Court case of Lewis versus Lewis? The answer to that question is yes, the trial court erred. And let me give you 4 reasons why I think that Lewis is a more applicable case. So here we go. Reason number 1, Lewis is a more recent case. It's more recent by more than 10 years, and the more recent case should be followed rather than the older case. Reason number 2, Lewis is a more specific case, and the specific case should always be followed over the general case. Reason number 3, there is a policy reason behind following Lewis. And that is, in Lewis, the Supreme Court talked about needing a more specific test so that the parties could adapt their behavior. I think that the more specific test is needed so that the parties can adapt their behavior. So there's a public policy reason, And then the fourth reason is that all the subsequent cases has cited Lewis with approval and followed the reasoning in Lewis. In particular, we cited a submission of supplemental authorities that we gave to this court just about a week ago. The Colorado Supreme Court, after briefing this case in April of 2018, decided another case where, again, they cited Lewis with approval and followed its reasoning in the specific circumstances where you have a close and confidential relationship. So that's four reasons why we think Lewis is controlling. It's a more recent case, it's a more specific case, it's cited with approval by subsequent cases by the Colorado Supreme Court, and it is supported by public policy, namely the policy of allowing the parties to adapt their behavior to the court's decision.
Counsel, I think the crux of the matter here is whether the parties were in a close, or whether they were close confidence, because the specific Lewis test applies when you have, quote, close family members or confidants, end quote. And they were not family members, so we don't have to consider that, because there's no claim of a common law marriage. But I guess what I'm struggling with is what kind of test do we use? What test does any court use to determine whether we have close confidence such that this more specific Lewis test applies? Because the trial court was aware of this test and simply determined that these were not close confidence.
I disagree. So let me start by agree in part and disagree in part. The court did not say that they were not close and confidential. They made no finding with respect to that, and in fact, at footnote 1 of the trial court's judgment, he specifically says, I'm not going to make that determination. So I disagree that the court analyzed it and then ruled against my client on that factor. To the contrary, the trial court ignored the Lewis holding and specifically said, footnote 1, he will not make that determination. So I'm not sure where you're getting that information from, but that is incorrect.
I think maybe I'm reading something into it, because the court was persuaded by the fact that Salzman involved cohabitants, as does this case, and coupled that with the fact that the court in Lewis did not overrule Salzman and didn't say that Salzman should have been analyzed differently. Didn't do either one of those things. So I think the court, if I can read between the lines here, was saying cohabitation doesn't fit within this.
I think you're reading far more into it. The judge certainly didn't make that determination, and I think you're reading way more into it than's true. And in fact, in the Lewis case, they were not actually related by blood either. And in fact, Lewis, they were ex-in-laws. So in Lewis, the Supreme Court found a close and confidential relationship when there was no blood relation whatsoever. Now, I do understand in the subsequent case in Sandstead, they were sisters and a mother, so there was blood relatives there. But still, nevertheless, if we look at all the Supreme Court precedent on here, they have not set out what the test is for finding a close and confidential relationship. But I can assure you that the trial court did not apply it here, did not make that analysis, and did not make that ruling, and specifically says he wasn't going to. So I would point out that. Second of all, I would also point out that the trial court here cited the dissent opinion in Lewis for the proposition that he was going to find some other damages. So not only did the trial court not apply Lewis, he specifically applied the dissenting opinion in Lewis. So I disagree with the assessment there. I would point out that when we look at Lewis and Salzman, it is true that Lewis did not say we're overruling Salzman in that sense. However, if you look at it, the majority in Lewis says we are adopting a more particularized test than what's in Salzman. Now, the dissentants in Lewis thought that they were overruling it. So it seems to be either implicitly overruled, where there's a close and confidential relationship, or implicitly overruled again by the fact that all the subsequent cases cite to Lewis with approval and don't mention Salzman. So number one, let's start by, I think the law, Lewis is a controlling law, and I think it has to some degree implicitly overruled Salzman. But more particularly to your question, Judge Jones, I think there's no question that the trial court specifically says, I'm not going to apply that law. I will not make that determination, and I'm not going to even inquire into whether there's a close and confidential relationship.
Now, you said that was in footnote 1 of the ruling?
Correct.
Okay, I didn't see that in there. Footnote 1 of the ruling I have says, "Court is aware that plaintiff's argument is that she is entitled to half the equity in the Perry Street home. However, based on the court's prior rulings in open court and its order Ray, defendant's motion for summary judgment will not inquire into plaintiff's arguments concerning damages regarding equity in this order."
That is true, and I think that that argument of equity stems from the Lewis decision. Again, if we look at Lewis, Lewis says in the context of a close and confidential relationship, the damages are determined by the mutual purpose of the parties. And here, the mutual purpose of the parties was an investment. And so he says, I'm not going to consider that, and he also says, I'm not going to inquire into that.
But that piece comes after the court finds there's a confidential relationship. It then
That's true.
apply- that-
That's true,
In
but
other
he-
words, that's not a piece that helps it determine whether there is a confidential relationship. So let's not get the cart before the horse here.
That is true. That is true. I agree with that. I agree with that assessment. I agree that that's the way the analysis should work. What I'm saying to you is unequivocally, the judge did not determine anywhere in his order there was or was not a close and confidential relationship, that he refused to do that, and he refused to have any evidence regarding that.
Counsel, may I jump in and follow up on a couple of questions that Judge Jones has? You keep using the term close and confidential relationship. Isn't Lewis really talking about close family members or a confidential relationship, suggesting that family members may fall within its rule as well as confidants? And so you have to determine whether, if they are not family members, whether they qualify as what in Lewis would be defined as confidants.
That is true. And in fact, I would.
Go
Oh,
ahead.
sorry to interrupt, Your Honor.
Go ahead.
Well, I would say that what the court is actually looking for is a relationship such that they would repose trust in that individual and not take normal cause of action. So what the Supreme Court is looking for is a close relationship or a confidential relationship such that that person would not, such that that person would put trust and would not take the normal course of action. Because I think the question here is, well, since you bought property together, why aren't both names on the title? And the answer to that question is there's a close or confidential relationship such that you would put trust in that individual and not take the normal course or steps of putting your name on the title.
And isn't the guidance in Lewis as to what might qualify as a confidential relationship what they describe on page 1143, which includes what you just talked about, which is when one party justifiably reposes confidence and a fiduciary trust, those kinds of things?
Exactly, Your Honor.
Do you believe that there are findings that the trial court made which established that this relationship was one between confidants?
Yes, Your Honor. And I would also point out in our opening brief, we cited to the undisputed evidence of a close and confidential relationship. And in the answer brief here, the defendant did not refute that in any way, shape, or form. And I think that evidence exists. Number one, they were cohabitants. Number two, that in order to buy the house, he specifically made a promise to marry. It's found in the record as well. Number three, that he needed her income in order to qualify for the house. So all of those things would indicate that there's a close and confidential relationship. And again, it was not a short-term relationship. The relationship had existed for more than 2 years prior to buying the house, that there was a close and confidential relationship such that she would let her guard down and not get it in writing and trust him without her name on the title. Yes. Once you've established that there's a close and confidential relationship, and I do think that that is the key thing the trial court did not rule on, but once we think it is undisputed, once you find that undisputed evidence, then damages are determined by whether there's been an abuse of that relationship or a substantial deviation from the mutual purpose. And here there's a substantial deviation from the mutual purpose because the mutual purpose was an investment. The mutual purpose here was they had said that they were renters, they each shared the rent equally, they went to purchase a house as an investment to make money. And in fact, Mr. Cummings' own text messages said, we're going to make lots of money. Well, at the end of the day, there's only one person who's made lots of money, and that's Mr. Cummins, and that's the basis of this suit. He deviated from their mutual purpose. Your Honors, if there's no further questions, I'll reserve the last 3 minutes for any rebuttal.
Okay.
May it please the court, my name is Ann Whalen Gill. My registration number is 14610. I'm here today representing Christopher Cumming, the defendant in this case. I believe that the record does not support that he promised to marry Miss Lucas. There was discussion of marriage at some point after the purchase of the house, but that cooled 1 year after they purchased the house. The relationship changed from romantic to merely friends. As to whether this was a confidential relationship such that there was a justifiable dropping of guard and not getting a written document, that was not decided by the trial court. I think it is an interesting question in this case. I think that starting with the Salzman case, which discussed cohabitants, much of the Salzman case talked about the change in societal norms such that the Salzman-Bacharach relationship was not purely a sexual relationship, and even though a sexual relationship was a component, that should not defeat the claims that were being brought forward in that case. So a great deal of the Salzman case talks about shifting societal standards, but does not get into a confidential relationship and whether that justified dropping guard. I would suggest, to the extent that this court wants to get into that, it's a very fine line that we walk, which was mentioned, I believe, in Salzman, because this state does recognize common law marriage, and there was no claim of a common law marriage here. So whether the fact that this was an intimate relationship, living together as a romantic couple for 3 years, does that justify dropping the guard and not requiring a written document? I would suggest to you that we're treading on dangerous ground if we go in that direction. But I don't think that we need to focus necessarily on that issue, because as the trial court focused, and I, in my brief, focused on the third prong of unjust enrichment, whether the defendant retained a benefit unfairly at the plaintiff's expense.
Counsel,
Go ahead.
all right. But Lewis dealt with the third prong.
Yes,
Expressly.
absolutely it does.
And I am troubled by your concession that the district court did not rule on this question of whether there was a close confidential relationship. Given, you talk about thin ice, where they're on the edge, whatever, well, that sounds like a factual determination that the trial court should have made. And it wasn't just the fact they were living together. It seems to me that's a threshold determination that the court has to make before deciding whether this particularized test of Lewis applies, and you're conceding the court didn't make it.
The court did not make that. I would argue to you, Your Honor, that the court looked at this as cohabitant with title in solely one of the cohabitants and found that much more analogous to Salzman, and thought that that was the prong to the basis for moving forward. I think that the court
But
was...
Salzman involved the in-laws,
No,
didn't it?
Lewis involved the
Lewis
in-laws.
involved the in-laws, excuse me. So, but the test is confidential relation, or family members or confidence. So it's not just family members. I mean, so why can't cohabitants be in this confidential relationship? You seem to be categorically excluding them, or at least the trial court was.
I think that it jumped onto the third prong of unjust enrichment without deciding that particular piece. And I think that if you focus on whether a benefit was retained that should not have been retained by the defendant without paying for it, that can dispose of the case without looking at determining whether this qualified as a confidential relationship.
But Ms. Gill, in Lewis, on page, I guess it's 1142, the court says, "We now consider whether this particularized third prong for unjust enrichment is necessary for claims arising from a close family member or confidant factual scenarios." And then it goes on, after considering that, to say, yes, it does. So I don't think you can jump to the third prong and avoid dealing with close family members or confidants. I think you have to determine as part of your analysis of the third prong whether you are dealing with confidants or close family members. So do you agree with that reading of Lewis?
If I'm reading in the same place, Your Honor, this is after the discussion of a particularized test in the landlord-tenant
It's
situation.
right before the paragraph that starts with "the case before us presents the difficult but not altogether uncommon circumstance."
Just a minute.
Halfway through page 1142.
And that proceeds to discuss various cases in which it talks about different cases that raised a question of unjust enrichment. And here is where the Lewis court started talking about a failed gift or contract between close family members or confidants. The claim arises from the close relationship. Thus, they reject the landlord-tenant requirement of malfeasance.
Right, but then they go on to ultimately say at the end of that same paragraph, "Thus, we find the need for a particularized third-prong analysis for such circumstances."
Yes, and I think that here it's extremely particularized. And here I think that the distinctions in the factual situations between the two cases of Lewis and Salzman suggest differentiations in the specific particularized test. So here,
isn't that a question then before the court to answer in addressing the third prong, is whether or not confidants are involved in this particular case?
it certainly would have made life easier if it had.
Yes, it would have, but
But I
We're
think
stuck
that
with where
it's
we are at this
not
point.
necessary when you look at the overarching nature of the third prong. Was it unjust for the defendant to retain the benefit without paying for it?
But counsel, in Lewis, what the court is saying is that in these kinds of relationships, we look at that question differently. There are different considerations than in the ordinary circumstance of people dealing at arm's length.
Well, I
And the
think,
court expressly refused to do that.
yes, well, first of all, I'd like to point out that Lewis was a 4-3 decision and with a pretty strong dissent. But I think that a lot of the Lewis case in the majority talks about a failed gift and then goes on and talks about the motives and intents that arise from this relationship of the parties. I think that Salzman, without articulating it as specifically as a mutual purpose, had a number of similar facts. Salzman did end up with the remand for factual findings that went to the relationship and the contributions. And I think that that is the foundation from which the majority was building in the Lewis case. I would like to step forward on that and point out that one of the things that I thought was significant is that the benefit that the in-law Lewises had received, which the court found was unjustly retained, was the profits when they sold the house. That is a significant factual distinction from the case that we have before you today, is that there's been no intent to sell the house. But what's even more important is that in this case, yes, Mr. Cumming bought the house as an investment. Ms. Lucas joined in that. She gifted him $1,400, which the court found went to the down payment. There is a gift letter at page 136 in the court file, in which she states she doesn't expect to be repaid. He did not need her income to qualify. Her income got counted when they did a refi down the road. But in terms of an investment, he was still interested in having that house as an investment. The relationship ended. She voluntarily left the house. How did Mr. Cummings significantly deviate from the purpose of investing in that house?
Well, there's still the threshold question. If there's a confidential relationship, that seems to be something that the trial court needs to decide whether there was a deviation. But he never got there, and in fact said he wasn't going to get there.
And he never found a deviation.
But he didn't find it because he said he wasn't even going to consider whether there was a deviation. I think that's the problem. The court didn't make the threshold finding of whether there was a confidential relationship. If there was, then the court did have to make a finding as to whether there was a deviation from the purpose. And we're up here left with no finding on the threshold issue.
There is no finding on that issue of a confidential relationship.
May I ask a follow-up question, though? In light of the findings that the court did make, do you agree that there are findings there from which one could conclude that there was a confidential relationship?
One could also conclude not. Societal standards have changed so much that I think you'd have to dig into that to decide whether that meets the definition in the case law. Was that a relationship that she reasonably deferred and did not require written documentation? Now, she clearly stated in her testimony that she wasn't concerned about the title, but I find that an unreasonable position. I think that most people who are engaged in an investment want to have their name on it. You don't just blithely go off and say, I'm going to believe this.
Well, but if there were a mutual purpose for them to buy the house, but for instance, her credit wasn't good, that may have been a reason why her name might not have been on the house and why the loan wouldn't have been pursued in both their names, right?
That's
So there
purely
are
a hypothetical.
There are circumstances which wouldn't defeat a finding of a confidential relationship and a mutual purpose, even though only one person's name is on the house.
And that's hypothetical. There's nothing in the record along that line.
Counsel?
Yes.
But if your position seems to be one should never repose that kind of trust in someone else and should get their name on the title. Well, if that's the case, then Lewis would have been decided differently.
Well, in light of Lewis, I can't go that far, but I think that the vast majority of people, when they're looking at major investments, are going to pay attention to the details of how it's titled.
Well, we can't adopt that rule because Lewis says that we can't adopt that rule.
Yes.
So is there another rule that you'd like us to adopt that is not entirely inconsistent with Lewis? Like, for example, what if they had lived together for 20 years and he had told her, honey, we're going in on this investment. Obviously, I'm not going to do a side agreement with you where we go out and get it notarized. Justifiable or not justifiable? Like, where do you want us to draw the line? Can't draw it where you're suggesting, because Lewis says we can't draw it there. Any
Right.
other place?
I think that, I'm trying to remember, it's a case I read quite recently, and maybe it was from this course, a 20-year relationship in which the court ruled that there was no marriage, that the woman could seek an interest in the property, but there was no mention of mutual purpose or anything of that sort. I'm sorry, I don't remember where I read that, just that I saw it quite recently. Your Honors, I would request that in light of the court's finding that it was unjust for Mr. Cumming to retain the benefit he received, but that he had already repaid the benefit he received, that you find your way to affirming what the trial court did in this case. Thank you very much.
Mr. Thomas, I think you have some time left.
Very briefly, Your Honors, I would point out that in this context of a close or confidential relationship, the Supreme Court has applied it in a number of different settings. Again, in the Lewis case, it was an unjust enrichment case. In the Sansed Corona case, which was a recent case submitted in our supplemental authorities, it was in the context of a constructive trust. And the Supreme Court cited very approvingly in a quantum Merowit case to Lewis. So it seems like they're willing to go beyond this context of just cohabitants. They seem, or even beyond the context of unjust enrichment, into various other causes of action as well. So I think that this concept of a close and confidential relationship is an important concept that the Supreme Court is bringing about across a number of different causes of action. And the reason, again, I want to get to that reasoning is it's not the close and confidential relationship itself. It's that the close and confidential relationship or close or confidential relationship causes one party to repose trust and not act as they would normally would. So the question you ask is, why isn't your name on the title? There could be 100 reasons why your name isn't on the title. Credit is certainly a big one. Convenience is often another one. In the Salzman case, actually, his name was on the title, but he quitclaimed it because there was a threat of a claim of common law marriage, so he quitclaimed it. There could be hundreds of reasons why people's names aren't on the title, and we can't think of every single reason why they might not be there. The question is the relationship close and confidential, such that they repose trust, and if so, then the damages are determined by the mutual purpose. Our contention here today, again, I want to say, is that we have made it clear that the evidence in the record in our brief, in our opening brief, was uncontested that there was a close and confidential relationship. That is not anything that was contested in the answer brief. And so we would argue that that's binding on the court, and we should just get to the point of there's a mutual purpose here. They've conceded the mutual purpose is an investment, and the only thing left is to determine her share of that investment.
Okay, so let me ask you this. You think then that we should look at the evidence and make the finding that the district court didn't make?
Well, Your Honor, I think that it's implicitly conceded since we've made it a point in our answer or in our opening brief that it's uncontested, and that's never been countered by the defendant in this matter. Isn't that a concession on the record? If we raise it in our opening brief, it's not responded to. Isn't it implicitly conceded by the defendant here today that there's a close and confidential relationship and we can just move forward to the next part of the analysis?
Well, not necessarily, because their position is it doesn't matter. Under Saltzman, it's closer to Saltzman, and so we don't even have to use this framework from Lewis. I mean, they could have said, but just in case, but they didn't.
They did not. That is true. That is true. That is true. Thank you very much. There is one last piece of thing I would like to say on the record. And I would like to thank our law clerk, Will Taylor, for doing a remarkable job of research and drafting these briefs. And I want to wish him good luck tomorrow on the Colorado Bar exam. Thank you.
Thank you to both counsel. The case is submitted, and an opinion will issue in due course. What shall we do on the 2:30?
I'm ready to go.
Okay. And then we're ready for the 2:30 docket whenever council are ready. I'll just remind council quickly that your cell phone actually has to be turned off and not to vibrate for some reason that I'm not clear on. And then, you're welcome. And otherwise, I think you should have received some oral argument guidelines, and if you have any questions, please let me know. Otherwise, we will assume that you are ready to go. I'll just also remind council that you've got 15 minutes per side, and you can just manage your own clock. That's the best way to do it. So if you wanted to reserve some time, that's fine, but you'll have to manage that time. And whenever you're ready to go, we're ready.
Good afternoon, judges. May it please the court, my name is Scott McGill with McGill Professional Law Corporation in Steamboat. My registration number is 8398. In preparing for this, of course, I went through all of the documentation in the case, and I have to say that I pity anyone that has to try and decide the facts because they are in total disagreement between the two parties. In reading them, it looks like there are two cases. I'm not going to address the facts except very minimally. Because of the number of issues, I have tried to break it down into the legal issues, which I will address, 3 of them, and the factual issues, which I won't address. The first issue is whether the appraisal umpire procedure is contrary to the public policy of Colorado. We believe that the Weezar case states that the primacy in Colorado is ready access to the court and a speedy remedy for every injury. Now, there's no question that arbitration is favored in Colorado, but the appraisal umpire process is not arbitration. There's a third party. He doesn't even make a binding decision. It's sort of arbitration mediation by agreement. I don't know what it is. It's been in effect for almost 100 years, no question. But that's when
I'm
things
sorry
work
to
out.
interrupt, but can I ask you just sort of like a broader question about your claim regarding the constitutionality of the appraisal provision? Are you saying that just facially appraisal provisions in a contract are unconstitutional? Or are you saying that in this case, because the appraisal process was used to preclude you from getting a remedy on your 2 substantive claims, that it became an impediment that is unconstitutional as applied in your case?
The latter, Your Honor. I
Okay.
couldn't have said it better myself.
So then let's just say that we agreed that the appraisal process did not preclude you from having your claims resolved on the merits. Is that an issue that we need to decide then?
I think that it is. That would be a result we would be looking for.
No, I'm sorry. Do we need to then decide whether the appraisal process was applied unconstitutionally in your case if we agree with you that you are entitled to go ahead and pursue the merits of your 2 claims?
No, I do not think you need to decide that
Okay.
in that event.
Thank you.
Continuing on with that, excuse me.
I'd like to ask a broad question as well.
Okay.
So that I can try to get my hands around all the issues here. I would like to know if you are saying, and it appears to me you are saying, that the the court should not have ordered the appraisal process to be followed.
That is correct.
Okay. I would like to know every reason that you contend the court should not have done that, because I had trouble from the briefs figuring that out. Every reason the court should not have done that.
Legal and factual, Your Honor.
Every one.
Boy, that's like an interrogatory.
Yeah, kind of is.
I guess I can list a few of them that come to mind. The first is, we don't believe that it was demanded. In 44 pages of the appellee's brief, never once does he point to where it was demanded. He keeps saying, or when I say he, I guess it's they, the corporation, keeps saying that the judge decided this, therefore it was demanded. But this was briefed extensively in the response to
the motion to stay the proceedings and compel.
And that's a factual issue?
That's a factual
Okay,
issue.
Okay, that's one.
Secondly, we think that it wasn't speedy or efficient, as shown by the fact that it took almost a year for it to be accomplished. My client wanted to know what the rules of the appraisal umpire procedure was, or were, and has every right to know that. Once the judge laid out the rules, we went forward with it willingly. But that brings us to the third point, which is that I think the whole procedure is ambiguous. The provision's ambiguous, as shown by the fact that Judge Hill had to set forth what she thought the procedure was, and with all due respect, she did not follow the contract at all. The contract, as I read it, says that there will be, in the event it's properly demanded, there will be an appraisal by each side. The two appraisers get together and see if they can agree. If they can't agree, then another appraiser, who happens to be called the umpire, is called in, and they submit their appraisals to him. And if he agrees with one of those, you have a binding valuation. The trial court judge took that a step farther and said that he has to have his own value. It gets even more twisted than that, because in fact, the third appraiser, the umpire, didn't come up with his own valuation. He hired a fourth appraiser, who I presume was his agent in essence. He had no authority to do this. He appointed himself as magistrate or special master, whatever you want to call it, and then said he's going to average them. There was no authority in the judge's order or in the policy for that to happen.
All right,
Ne-
but that's an issue as to whether the process was properly carried out. That's not really an issue as to whether the court should have ordered it in the first place.
That is correct. I guess I'm digressing or following my own logic. Other reasons why the court should not have ordered it?
in the first place.
Offhand, Your Honor, I can't think of any.
Can I, sorry,
Go ahead.
I was just going to jump in with another sort of big picture question.
Okay.
It seemed to me that your objection to appraisal was that it was presented by the trial court as an alternative to litigation. And so that seemed problematic to you. That's what I read in the briefs, that your issue with the appraisal was really that it was being presented as an alternative, and you didn't think it was a good alternative. Let's say it's not an alternative. Let's say litigation is available. Is it your position that what you want to do in the litigation is re-argue the value of the truck? That, if you get to go to have your claims resolved, do you, as part of what you want to do in the litigation, relitigate the value of the truck, or you're willing to take the appraised value of the truck as long as you can go to litigation on your claims?
I think we would be willing to go to litigation with the value having been established, if it's the value that the umpire's appraiser said, which was almost $55,000, not his decision that he's going to average things. If he didn't make his own appraisal, as Judge Hill ordered him to do, he has to rely on the appraisal that he got from his agent.
Okay,
would
but
be
so
our
then the
argument.
answer is no, you're not, you are contesting, even if you get to go forward with the merits of your claims, you are challenging the valuation of the truck. You want to relitigate
That the
that,
judge,
that the umpire
found-
came up with.
his suggestion of value, as he called it,
Correct, his 39 grand or whatever it was,
yes.
okay.
All right,
And,
Coun-
sorry, no, go ahead.
Okay, so I'll give you another hypothetical. If we determine that the appraisal process was validly ordered and that there's not a problem with the appraisal valuation, what is left of your breach of contract claim? Not the bad faith claim, the breach of contract claim.
I think the timeliness of it, which also is part of the bad faith.
All right, so if,
claim.
so the timeliness of requesting the appraisal?
No
Or the of payment, just of payment, generally speaking?
yeah.
Okay, so that's really not any different, though, than the bad faith claim.
No, and similarly, I think the fact that their behavior during the period where they were making, frankly, what we thought were lowball offers, and then once I was hired, it went up, and then it went up, and finally, when we said, this is bad faith, all of a sudden they demand appraisal. I think that's not part of the breach of contract claim, but it's definitely part of the bad faith. Actually, I think it would be part of the breach of
Yeah,
contract.
I'm just trying to separate out the claims. I think I understand the bad faith claim pretty well. I'm trying to understand if the value of the vehicle has been determined pursuant to a contractually agreed process.
Mm-hmm.
It seems to me that can't be a breach of contract. So what is left of the breach of contract claim itself if we determine that the process was validly invoked and ordered and that there's not a problem with the number that the umpire came up with?
I think the two are so interrelated that the handling of the claim is also part of the breach of contract.
Okay.
For instance, that 60-day rule that the Division of Insurance has could be an item of evidence. I actually really don't want to rely on that. I think it's more the reasonableness of it, which is the,
So it seems then that your two claims are largely overlapping, if not entirely. Is that accurate?
that is correct.
Okay.
Could I ask a clarifying question about that? I thought that you had asked for additional damages beyond the value of the truck. Are you not seeking?
Well, yes, there are statutory damages of,
No, I'm sorry, for like the storage of the truck and
There's like a
then-
$3,000
Yeah,
amount.
there were other, I think,
that is correct.
that they breached. My understanding was that the breach of contract claim was based on the fact that they also did not pay the entire claim, which you say included storage fees and
Yes, they
also maybe
agreed.
some like loss of wages or something, loss of work.
Yes. I don't think that's under breach of contract, though. I think that would be under the bad faith damages, the loss of wages. The storage definitely was agreed to by the adjuster,
Okay, and that.
although they put a time limit on it. But then we would contest that they have the right to say, oh, we will pay for storage, but we cut it off on a certain date until they could have come and gotten the truck at any time.
Okay, I'm just trying to figure out if that forms any basis for the breach of contract claim.
Yes.
Okay.
We've sort of already addressed the fact that the January 3rd, 17 order establishing the value was void, in our opinion, for the reasons that I just mentioned. I would reserve the remainder of my time for rebuttal, since I only have a minute. Thank you.
May it please the court, my name's Stuart Morse, MORSE number 16978. I'm here on behalf of my client, United Fire and Casualty, to request this court affirm the trial court. May it please the court and counsel, hopefully some of my prepared remarks are actually going to address some of the very questions that I think both Judge Harris and Judge Jones just asked. But really and truly, what this case is about is it's an appeal about whether to uphold the trial court's enforcement of a contractual agreement between parties to determine the value of a loss. And the trial court found that the appraisal clause in the policy was valid and enforceable, and not only that, was an important element of Colorado's public policy to support alternative dispute resolution. And in this particular case, that's exactly what the appraisal process was.
Counsel, use that phrase, alternative dispute resolution, but this wasn't a mediation. This
That's
wasn't
true.
a resolution of claims. This is a resolution of one factual issue among many in a claim, the value of the vehicle.
I beg to differ, Your Honor. I believe, and this goes to your question a moment ago as to what's left. The only thing that was pled in the operative complaint in this case was the ACV of the vehicle. The only contractual item that was ever brought in any operative complaint in this case was how is the actual cash value of the lost property determined. Specifically, the policy says the limit of insurance, and this is found in the record on appeal at 507, is, and this was also cited, I would point out, in the complaint itself. I believe on page, I apologize. It's in the operative complaint, and it's paragraphs 28 and I believe 15, but don't quote me on that. But they broke down the policy language, and I'll read the policy language. It's found specifically, you can see it easily in the record on page 507. Limit of insurance, the most we will pay for any loss in any one accident is the lesser of the actual cash value of the damaged or stolen property as of the time of the loss.
But counsel, how does the fact that that amount has been determined decide whether there was an unreasonable delay or denial of that value?
I think that's an excellent question, Your Honor. And the fact of the matter is if you look at the Sanderson versus American Family case, you look at Vaccaro versus American Family, you look at Zollman versus Pinnacle, the fact of the matter is the facts in this case were all undisputed as to when things happened. And the loss happened on June 27th. By August 5th, the claimant had a check in its hand. By August 14th, that check was increased. The judge found, as a matter of law, that was a reasonable process. And Vaccaro versus American Family, Zollman versus Pinnacle, Sanderson versus American Family all state that when the facts are undisputed, and the facts of payment are laid out in this record, when the facts are undisputed, the court can determine, as a matter of law, whether there was any bad faith or any statutory, for lack of a better phrase, although I don't really like calling 10, 3, 11, 15, and 16 statutory bad faith, but so many people do, that the court can determine that. But the point being is, in this particular instance, there is a great misapprehension in the appellant's briefs on bad faith law. It starts with a couple of things. Number one, it starts with the statement that an insurance company owes a fiduciary or a quasi-fiduciary duty to an insured. That is not the law. Goodson versus American Standard says that is not the law. Savio says that is not the law. Instead, it may be the law in a third-party bad faith context, but not in, as in this case, a first-party claim where an insured is making a claim directly to its insurance company for payment, and there's a dispute over that payment. Indeed, the Supreme Court in Savio, Travelers versus Savio, says that an insurance company has an obligation to vet those claims, and that in fact, during the process of negotiation, which it is very apparent in this case was going on, every time United Fire would present a check, and unfortunately, Andres Trucking did not supply any real evidence of value other than his personal opinion of his value. Indeed, even their appraiser did not use any comparable values for determining his determination of loss. But when that occurs, when there are negotiations, the law is very clear that the duty of good faith, such as it is in that context, is suspended. And the courts that say that are Buchholz versus Safeco, which really a lot of the courts go back to. The Sanderson versus American Family case adopts that, as does Savio versus Travelers.
Counsel, I guess where I'm getting hung up, though, is I had understood the trial court's order as simply saying that because there was an appraisal now, there are no claims. That's simple. Not making a ruling that as a matter of law, there was no bad faith under the facts of this case.
I would disagree with the court in that regard, Your Honor, with your question. If you look at page 3 of the court's September 15, 2016 order, this is the order regarding defendant's motion to strike plaintiff's amended complaint. The last paragraph on page 3, which is Record on Appeal 162, the court opined, this is the trial court speaking, the court opined that the appraisal process did not violate defendant's contractual and statutory obligation to adjust the claim. Although the court did not specifically refer to the two statutes raised by the plaintiff in its response opposing defendant's motion to stay proceedings and compel appraisal, CRS 10-3-1115 and 1116, the court's conclusion that the process did not violate the defendant's statutory obligation included those statutory provisions.
I get that, but the court is only saying that by invoking a statutory process, that can't be bad faith. I get that.
Agreed.
But that's not all of what's alleged in the bad faith claim.
It is what's all that's
I thought it
alleged
was
in
an
the bad faith.
unreasonable delay in payment.
Your Honor, the record shows that that is demonstrably false.
Well, that, I understand that's your position, but I don't see any ruling by the trial court to that effect. I see a ruling only that
I see what the court is saying.
that by requesting the appraisal under the contractual provision, that's not bad faith. I get that, but
The
I think you're
court's
trying to.
phrase was, there is nothing left to do, and therefore the court entered judgment. And that issue was specifically before the court in determining that, or making that statement, because what happened was after, and frankly, the delay, the court found, and I believe this is a discretionary finding that this court cannot overturn absent an abuse of discretion. The court found specifically that the only party that had injected any form of delay in this process was the plaintiff.
But under what rule is the court making findings? We're at the 12B5 stage, aren't we? I mean, are those cases that you cited about that when the facts are undisputed, the court can determine reasonableness as a matter of law? That sounds fine, as long as we're at the summary judgment stage. Those are 12B5 cases?
No, they are not, Your Honor. I
Okay, so
would
why is the
specifically
court
tell you
making-
that my belief is that they're CRCP 56 cases. However, this case was something of a hybrid, and I don't know that the court specifically stated that her findings were made pursuant to 12B. That's one of the reasons why
What else
we
could they
didn't.
have been made pursuant to? You
You can-
filed a motion under 12B5 to dismiss.
I did not.
What did you file the motion under?
I believe I just filed a motion to dismiss. I don't know that I specifically cited the rule. But A rule for summary judgment can be filed at any time, even before an answer is filed.
But there wasn't any, I mean, where
Sir-
was the discovery, and where were the undisputed facts laid out, and where was the
The undisputed-
move-in's presumption and all the inferences in favor of the non-movement?
In the verified complaint. It was a verified complaint in this case.
So you're
And so
saying
the
this was a
court,
Rule 56
the
procedure?
the
that
court,
occurred?
I believe that this court, it doesn't matter. It's in this particular instance, it's 6 of one, half dozen of another. Because the plaintiff never pled any additional facts. The plaintiff never pled any entitlement to any element of damage over and above the actual cash value of this vehicle. There's no provision in the insurance policy cited in the complaint or under which the claim for relief is presented for any other element of damage. That element of damage was determined, the court said, under the appraisal process, which is an appropriate process to follow in the state of Colorado and is supported by our public policy. And then the payment was made, the record is abundantly clear, within 60 days of the time frame that is demanded by the claimant in this case. The payment was made January 14th. At the earliest, at the very earliest, the appraisal amount was determined on November 30th. However, because the trial court had some questions about what do you guys mean when you're filing these pleadings telling me that the appraisal process is over, the court asked us to brief it. We briefed it, we laid out the facts, and she said, oh, okay, I get it. And she made her determination that there was nothing left to determine because the only claim made had been for the actual cash value. That actual cash value had been determined as private parties can determine to do in their private contractual dealings with each other. And the point is, I would like to point out, is that Heuser has nothing to do with this case. It was an old case decided under an old statute that no longer exists that required statutory personal injury benefits be offered. And the Supreme Court said that the arbitration process diluted the statutory mandated coverages. There is no statutory mandated coverage for property damage.
Can I just get some clarification then?
Please.
It sounds as though your position is, even though no one requested and the court did not state under what procedural rule it was proceeding, we should construe the court's ruling as granting your motion for summary judgment, which wasn't specifically made?
Yes, Your Honor. I think that is a fair assessment of what the court can do. I think that the court, frankly, could dismiss it either under 12B grounds because the complaint was determined in a verified complaint and those were the facts upon which the court made its decision, i.e., what was the contracted issue. It was determined what the value was and then payment was made. Now, I would have to concede the issue of ultimate payment after the appraisal process was certainly not in the complaint. So I guess in that regard, it would almost have to be a 56 motion.
Counsel, I see a couple problems with that, though. The law is quite clear that if a court is going to convert a motion into a motion for summary judgment, it must give advance notice to the parties before it does so, so that they can present any materials in favor or in opposition to such a motion. I see nothing of that in the record. Secondly, I'm also not aware of any rule that requires a plaintiff to plead with specificity the damages in their complaint. They can if they want to, but they're not bound by it. They can simply say, and as a result, the plaintiff has been damaged in an amount to be determined at trial.
I disagree with the court in that vein, Your Honor, because I believe that the Supreme Court has changed Colorado from being a notice pleading state to being a plausible pleading state.
Yes, but not as to
And-
damages.
No, but
Plausibility has to do with liability and the nature of the claim. There is no authority that says, for example, that Rule 9B under the civil rules requires specificity as to damages.
Agreed, Your Honor, but the claim that was made as to the breach of contract and therefore the bad faith breach of contract was based upon one particular item, and that is the limit of liability for the property loss. And that was specifically pled and incorporated into the complaint. And therefore, the court was free to make its legal determination on that ground.
Well, again, though, it didn't make any determination about delay. It just said, well, invoking the appraisal process is in bad faith. Okay, but that only goes that far.
Well, the court found that the appraisal process had been timely invoked, and I believe that the court has that right as a matter of law. It's just as if a court is making a determination as to whether there is an offer, whether there is acceptance, whether there is consideration. These are all threshold items that courts regularly, and I think as a matter of law, are required to determine. This was no different in that, was there a contractual provision that required the appraisal process? Clearly there was. The court made its finding that that appraisal process had been timely invoked. That is in its order. So
I'm sorry, what does that mean, had been timely invoked? I mean, I saw where the court makes a determination about when it thinks that United actually invoked the appraisal process, but what does that mean that the court made a finding that it was timely invoked? Timely as to what?
timely as to not bad faith, timely as to not an unreasonable delay or denial, because then the court went back and said, listen, I considered this, attorneys. This is what I meant when I said defendant's motion to stay and compel under 10, 3, 11, 15, and 16, it was not under the facts of this case at odds with the statute or with the policy language, which required appraisal.
Counsel, though, it seems to be that an insurer could just lowball an offer and then later invoke the appraisal process. And you're saying that because, or so long as, that process is timely invoked, they're off the hook for the lowball. In other words, they could use the appraisal process as a means of delaying payment in bad faith. Here's a dollar.
I certainly wouldn't.
Here's a dollar to settle.
Okay.
Here's a dollar to settle, and we're invoking the appraisal process, which is going to take a year,
But, Your
like this
Honor,
one did.
under the facts of this case, that is clearly not what happened, number one. Number two, the law says that an insurance company is free to hire appraisers to assist it in determining what the value of the property is, and that is, in fact, what occurred in this case. Number three, the law is that the insurance company, once that offer has been made, has no obligation to continue to negotiate. And the fact is this gets back to the fair debatability arguments that are presented in the Sanderson, the Vaccaro, and the Zolman cases. Without more, fair debatability of the amount alone might not be a defense to bad faith, but under the facts of this case, they clearly are, because the facts clearly showed that United Fire bent over backward getting multiple appraisals for the value of this property.
Okay,
I
and
note
there's
that
where I'm
I'm
going to have
well
to
over
cut you
time,
off. Yep.
But I appreciate the court's questions, I truly
And
do.
thank you for answering
And,
everything.
thank you
And-
for your time.
We will add an extra 3 minutes, Mr. McGill, to your time, just to even things out.
Thank you, Your Honor. I don't think I'll need it,
Okay, don't feel like you have to take it.
I'd like to point out the following things. First, opposing counsel keeps talking about the operative complaint, and the reason he talks about the operative complaint is even though the rules of civil procedure provide that a plaintiff may amend as a matter of right its complaint before an answer is filed, my client was not allowed to do that. In fact, there's a motion to strike the amended complaint. So the fact that the court was ruling on the first complaint is, I don't suppose it's irrelevant, but that's not the full story. There would have been more, as I'm sure all of you know. cases sort of take on a life of their own, and you begin to see new angles and new causes of action, and you amend more than once. The defendant has been extremely fortunate in being able to stop this before we even were able to push the gas on the green light. Secondly, all of the checks that were sent were in full and final settlement. These were not bona fide offers of an undisputed amount. They wanted to end it right then and there. That's part of the bad faith. Even after the judge adopted the appraiser's or the umpire's suggestion of value, which we contest, when United Fire sent the settlement check, one more time, they retained the $1,000 deductible, which they've admitted is right in the policy that does not apply to fire losses. And there's a letter from the supervisor, and I think it's in the record, but I can't be certain.
Counsel, you're not suggesting that whenever an insurance company tenders a check that's less than what the plaintiff demands, that's bad faith?
No, I'm not suggesting that. That may be the exact correct amount.
Okay.
But we didn't think it was in this case,
Right.
Your Honor. I'd also point out that the appraisers and the umpire all failed to determine the actual cash value and the amount of the loss, which is what they just came up with one number. That's just one more problem with the whole procedure.
Mr. McGill, can I jump in here? I have a factual question. In your reply brief, it seemed like in footnote number 2, you acknowledged that United had invoked the appraisal process in January 2016. You say United unequivocally requested the appraisal process be initiated.
I would have to look at that, Your Honor. I have it here.
Okay.
Could you point me to the correct page, Your Honor?
Oh, yes.
Or I can probably find it. It's not very long.
On page, hold on, I got it. Page 7, footnote 2. It says, "The January 4, 2016 correspondence was the first time it unequivocally requested the appraisal process be initiated." So that sounded to me like now everybody's on the same page. United,
Thank you. And what is your question?
my
Your
question
Honor?
is that a concession or some acknowledgement? I mean, that's what it reads like to me.
I think after a series of letters where they suggested that
Right.
my client do it,
Right.
apparently this is the time that UFG did finally demand it. Well,
Okay.
actually, they didn't demand, they requested once again.
Okay, and so is that your argument, that because they unequivocally requested it but did not demand it, that it was not proper invocation of the appraisal process?
Yes, I don't think they ever said we demand, and I do think that's
what's
necessary.
required? Yes, you think that's necessary?
That's what it says in the contract. You
Got it,
have to
okay.
demand it.
Okay.
And I think I had concluded, well, I have 31 seconds. Again, we would say that the timeliness of the demand is a jury question. That's not for the trial court to decide. And that does conclude my rebuttal.
Thank you.
Thank you.
to both counsel. The case is submitted. We'll issue an opinion in due course, and thank you very much for your arguments.
Thank you.
And now we're adjourned.